not my first visit to the NUS, as has been indicated, and I've always enjoyed and benefited from my visits, and this time is no exception. I'd like to thank the director and the deputy director of the Centre for Law and Business for the warm welcome which they've given me and the facilities which they provided. And I'd also like to thank the other members of the NUS Law faculty with whom I've had a chance to interact. Okay, so now to the lecture. Can I first check that I'm audible, neither too loud or too soft? Yeah, good. Okay, so what I want to talk about today are the ways in which the views of policymakers and corporate law scholars about the appropriate function of corporate law has changed over the past 50 years or so. Now, the beginning of the lecture operates at a fairly high level of generality. But in the second part, I will look at a more micro level at some law reform which have actually happened or which are proposed, some of which I think are useful, some of which I'm not so sure about. Um, so So what I want to look at are two recent periods when the uh, proper function of company law was very much at the top of the minds of policymakers. First period runs from somewhere in the 1970s up to the great financial crisis at the end of the first decade of this century. And this was a period when the law and economics approach to corporate law was dominant. And I think looking back on that period with hindsight from today, it's pretty clear what the lessons learned from that period were. The second period began with the great financial crisis and is still ongoing. And the contributions of the current period to our views of what corporate law should be doing, I think, are still greatly controverted amongst policymakers. So it's easier to see where the battle lines have been drawn rather than to declare victory for one side or the other. Now, what I want to try and argue in this lecture is that the lessons which were learned in the first period I referred to are still valuable, and indeed they should animate the design of most of our corporate law. So the focus was too narrow. By internal relations, I mean the focus was on relations between shareholders and managers, between controlling and non-controlling shareholders, between creditors and the company, and to some extent even employees and the company. In the second period, the focus has moved to include the impact of the company on people outside the company. That is to say, people who have not entered into contractual relations with it. And obviously, this second period focus has the potential to expand the functions of corporate law. And the two questions which arise obviously are what functions should be added, and are the functions that are added in the second period incompatible with the lessons learned in the first period. And what I hope to do in this lecture is to sort of struggle some way towards trying to answer those questions. Let me start with the first period, um, beginning in the 1970s, when something really wonderful happened to corporate law. Because before that, when the focus of legal scholarship was on the doctrinal coherence and elegance of legal subjects, corporate law was a bit of a laggard. It was certainly a long way behind contract and tort. But the law and economics approach had corporate law as one of its principal examples of how its approach could be used. So far from being a laggard, corporate law suddenly jumped to the front of the field rather than being a back marker as it had been previously. So, how did the law and economics approach conceive of the core functions of corporate law? The proposition can be put very simply. The function of corporate law is to reduce the costs of carrying on business in the corporate form. Um, Now, that doesn't tell you very much about what the particular rules of corporate law should be, but we could note two things immediately. One is that this is a definition in terms of efficiency, operating efficiency, not a definition in terms of distributional goals or fairness. Secondly, however, one can make a social welfare claim for this proposition, namely that if corporate law is fashioned in this way, then society will obtain the goods and services that companies produce at a lower cost than if the company's operating efficiency were pitched at a lower level. Now, obviously, the operating efficiency of companies is determined by a wide range of matters in addition to corporate law. But the claim of the law and economics school was that um, uh, good corporate law could make a significant contribution to the efficient running of companies. So let me give you just one rather simple example. The current rule, as you well know, is that once shareholders have made a contribution to the company in exchange for the shares, they can't unilaterally ask for the money back or even the current value of their contribution. Um, Suppose the rule were the other way round, and the shareholders could at any time ask for the value of their contribution back from the company. I suggest that this would be an extremely inefficient way of running a company for two reasons. First, it would make it very difficult for the company to raise debt finance because the creditors would never know what the size of the equity cushion in the future was going to be. And even more important, it would make it very difficult for the management of the company to turn the company's cash into idiosyncratic assets. That is to say, assets which have more value within the firm than outside the firm. In fact, the management would have to run the company with a very high level of liquidity, almost as if it were a mutual fund. And this seems to me not an efficient way of running a modern industrial or services company. Now, I don't have time to go through all the insights which the law and economics approach generated in relation to corporate law, but let me just concentrate on one thing, which is agency theory, because I think this theory was at the heart of how law and economics approached corporate law. Um, and Let me say right at the beginning that agency theory is not a prescription for a detailed set of rules which all corporate laws must contain. It's a way of framing the problems which corporate law has to address. It identifies a set of legal techniques which are available for solving those problems. And of course, it indicates that the choice amongst those techniques should be the one which most directly contributes to the uh, operating efficiency of the company. So agency theory is not a theory, though some people think it is, but it's not a theory which predicts that all corporate laws around the globe will end up looking the same. Agency theory is very sensitive to context, and it could be that rather different looking corporate law systems are equally efficient. Uh, but that's not to say either that because corporate laws are different, they are equally efficient. Okay. Um, Now, agency theory grew out of a rather simple insight, which is that in order for businesses to work effectively, they have to bring together inputs from a number of sources and combine those inputs to produce whatever the company is aiming to produce. So the providers of the inputs in corporate law terms are the shareholders of various types, creditors, trade, and financial, and employees from the top management downwards. So on agency theory um, attempts to address two problems in this setting. Uh, One is to ensure that the legitimate expectations of the providers of the inputs are met so that the company can obtain those inputs on good terms. And secondly, to deal with the conflicts which are likely to arise in the running of the company among the providers of these inputs. And I suggest that these are important and continuing functions for any corporate law system. So let's look at agency theory a little bit more detail. And you have to start with these two gentlemen, economists, not lawyers. Um, and as you can see from the bottom of this slide, they identified an agency relationship as one arising when a principal enters into a contract with an agent, which involves an inherent element of discretion. And it's the inherent element of discretion that's crucial, um, because without it, the principal would be able to tell the agent what to do in advance. As the economists say, the principal would be able to write a complete contract for the agent, or the principal would be able to costlessly intervene if the agent started doing something which the principal didn't approve of. But given the inherent element of discretion, the principal is exposed to the opportunism of the agent, either disloyalty or slacking. Now, there are obviously various self-help remedies that the principal could resort to. So the principal could say, well, instead of paying the agent by time, you're going to pay the agent by results. But that won't necessarily work because the agent might be completely loyal and hardworking, but the world might just be against the agent. And the results of the agent's activities are just rather meager from the principal's point of view, or vice versa. So payments by results may either over remunerate or under remunerate the agent, and in neither case produce the appropriate set of incentives. And this is where the law and economics approach saw a role for the law. The law could either provide substitutes for self-help or do things which made self-help operate better from the principal's point of view. So you might think about uh, imposing fiduciary duties on directors as generating a um, a substitute for self-help, or you might think that requiring the company to disclose information to investors before they become shareholders, or enabling the shareholders easily to get rid of directors they disapprove of, as to be examples of the law facilitating self-help. Yeah, thank you. Thank you. Okay. Um, Now, there is obviously one uh, very big problem with the Jensen and Mecklin view of what an agency relationship is. Uh, which is that it really works well only in relation to the relationship between dispersed shareholders and the management of companies. Um, and okay, that's true. That's the situation you find in publicly traded companies in the US and the UK, but they are outliers in global terms. In most jurisdictions, shareholdings are concentrated, as indeed they are in UK and the US once one moves away from publicly traded companies. Uh, and of course, with controlling shareholders, they probably can monitor what the management of the company is up to at a cost which is not disproportionate to the size of the investments. Um, and in any case, I doubt very much whether a non-controlling shareholder regards itself as having delegated a task, because the non-controlling shareholder is the principal in Jensen and Mecklin's terms. I very much doubt whether the non-controlling shareholder regards itself as having delegated a task to the controlling shareholder, and still less that the controlling shareholder, the agent, regards itself as having received a delegation of authority from the non-controlling shareholders. So if one's going to use the agency theory across jurisdictions and across different types of company, one needs, I think, a slightly broader definition of what an agency relationship is. And that is what's provided in the book, The Anatomy of Corporate Law, of which I should disclose at once I am one of multiple authors. So you can see that what happens in the anatomy book is that delegation of a task is replaced by the notion of reliance. So a principal is anybody who's entered into a relationship with a company in which their welfare is dependent upon the actions of others. And so there's the notion of lack of control, and the notion of vulnerability are still there, but they are not derived from delegation of a task. They're derived from the nature of the relationship that the principal has entered into with the company. And if you're prepared to accept this broader approach, then you can apply agency analysis across the board. That's how it could work. You can see you can have managerial agencies costs, you can have ownership agency costs, and you can have contractual agency costs. And what the anatomy book does is do a sort of high-level worldwide analysis of the choices different jurisdictions have made in this respect, um, building on the work of scholars from around the world, including from this university, who've been particularly influential in the analyses they've done of relationships between controlling and non-controlling shareholders, including different types of controlling shareholders. So I think agency theory can be made to work across the board. Just one final point about it. Although I think it's not a logical deduction from agency theory that the shareholders should have control of the company, agency theory points strongly in that direction. It's true that control could be used to reduce the agency costs of any of the groups on this slide. And we know, don't we, that creditors often bargain for control, at least in certain states of the world. But the notion that the default rule should be shareholder control is derived from the fact that, at least for ordinary shareholders, their contract with the company gives them very little contractual protection. They may expect a growth in the value of their shares, they may expect dividends, but there's nothing in their rights against the company which gives them a contractual entitlement to that. Indeed, that's the whole value of equity risk capital to the company, that the company doesn't have to pay out dividends if it's not in a position to. So the argument for shareholder control is generally based on the argument on the proposition that the contractual protection which shareholders have is much less than the contractual protection which creditors or employees or non-ordinary shareholders have. Those other people uh, don't have complete contractual protection, but they have a higher level of contractual protection. Okay, so that's the first period. Um, and my argument has been that in this period, the view was that corporate law should be fashioned in such a way as to reduce the costs of running businesses in the corporate form. Things, however, changed in 2010 for, it's not perhaps entirely clear why, but we can point to a number of plausible causes. The great financial crisis, I think, reduced people's confidence in private organizations. At the same time, the United Nations Human Rights Committee was building up a head of steam in relation to international conventions on human rights and seeking to co-opt companies to improve the rather low level of adherence by states to those conventions. And of course, there's the uh, climate change, the rise of climate change to the top of the policymakers' agenda globally. Now, um, so the focus shifted to the impact of company on those outside it. Now, the first thing to say, perhaps, is that this development is perfectly encompassable within an economic analysis. Um, Harms which the company inflicts on outsiders and which the company doesn't pay for are referred to by economists as negative externalities. And of course, economists don't like them because from an economist's point of view, if the company doesn't bear the full costs of its production, then it produces its goods too cheaply and society consumes too much of them. So some mechanism is needed to bring the cost of these externalities back onto the company in order that the market system can operate. So although the economist's view of what's wrong with externalities are different, indeed dramatically different from what human rights activists think about externalities and about what climate change activists think about externalities, ethical concerns in the first case, intergenerational concerns in the second case, all three analyses actually point in the same direction, that externalities should be controlled. So there is an initial puzzle as to why the corporate law analysis in the first period spent so little time on externalities. And I think this is not because the theorists in the first period thought externalities were unimportant or didn't exist. It was because they thought that the problem of externalities was going to be taken care of by bodies of law other than company law. So to give a simple example, if the company pollutes local land or local river, the thought was that environmental legislation would bring the costs of that activity back to the company. And so there was a sort of a thought, and I must say that was an approach which had the advantage of catching non-corporate polluters as well as corporate polluters. So there was a sort of specialization envisaged. Internal affairs of companies dealt with by corporate law, the impact of companies on those external to it were dealt with by other bodies of law. So why has that convenient view been challenged. Um, and the view that's the argument that's given in lots of corporate law writings today, or it's more often asserted than proved, I think, is that state action on which regulation depends is broken. It doesn't work. It doesn't produce effective regulation any longer. And the reason usually assigned to explain that is that companies are able to manipulate the legislative process so as to prevent the emergence of laws they don't like. So I have two problems with this view. One is it's not obvious to me that state action and regulation are broken. Um, you can point, I think, to actions which have been taken in the developed world, which have been very effective in addressing, for example, climate change. So if I think about my own jurisdiction, I could point to the phasing out of coal-fired power stations, the encouragement of wind farms, which some periods of the year are capable of supplying the whole of the electricity needs of the UK and leading to the export of some electricity to other countries. The state has set dates for the phasing out of the sale of new cars with internal combustion engines and also for the uh, ban on installing new gas boilers or furnaces in new homes. So now, obviously, one can argue that the state should have done more, should have done it more quickly, but this doesn't seem to be evidence that state action is broken. My second concern is that um, the fact, even if the state has deficiencies in the way it's tackling climate change, one needs to be sure that companies can do a better job before one shifts the burden of action on to them. Um, and it's not clear to me that this is the case. Indeed, I would say that normally the state has a comparative advantage in addressing climate change issues, greenhouse gas emissions, for example, as compared with a company, because the state has greater powers of coordination and indeed greater political legitimacy to exercise those powers than a company would. So let me take fossil fuel producers, major contributor of greenhouse gas emissions. Um, the emissions associated with the activities of oil companies and coal companies are a very significant contributor. Okay, but the crucial word in that sentence is associated with. It's generally accepted that of the greenhouse gas emissions produced by oil companies, 85% of them occur not when the oil is extracted from the ground or when it's later refined, but when it's used by consumers, i.e., after it's left the hands of the oil companies. These are what in the jargon are called the oil companies' Scope 3 emissions. Um, and uh, and one has to ask whether it isn't the state that has better capacity and more political legitimacy to tell consumers what they are able, what they're permitted or not permitted to do with the use of oil or gas. So I would, in general, oppose the shifting of the burden of controlling externalities from the state onto corporate companies and corporate law. But it seems to me it's legitimate to use corporate law to nudge companies into thinking more deeply about uh, um, their impact on those outside the company. And so let me give you a couple of examples, one of which I think is an acceptable use of corporate law to nudge uh, companies uh, in this way. And the other, I think, really goes beyond the bounds of what is acceptable. So we already do a great deal of nudging of companies through corporate law, don't we? With um, the extensive rules which have developed exponentially in the last few years on non-financial reporting. So the companies now are required to tell the world a lot about their impact on those outside it. But these two examples go beyond just reporting. So this is uh, an article from a proposed EU directive, which I would predict is highly likely to be adopted this year. And as you can see, what it does is require companies to have business plans for bringing their activities in line with a sustainable economy. It only applies to big companies, to say companies with a certain level of turnover in the EU. But this audience may wish to note that if a company exceeds the relevant turnover level, it will be subject to this requirement, whether or not it's incorporated in the EU. So companies incorporated outside the EU, if they exceed the threshold, will have to comply with this article. Well, they'll have to comply with whatever the member states of the EU do when they transpose this article into their national laws, because as you can see, the article is in fact directed at member states. So what it actually will mean in practice will vary from member state to member state. And that's perhaps the point to make about it. If member states interpret this as merely requiring them to ensure that the companies falling within the coverage of the article have plans of this type, and most of them, in fact, do already, publish them and expose them to public scrutiny, then I think this is an entirely uh, legitimate use of the law to nudge companies in a particular direction. If, on the other hand, member states interpret this as uh, encouraging them to subject companies' plans to review by courts or regulators of a detailed and intrusive kind, then this, of course, will cut against one of the uh, lessons learned in the first period, namely that boards should be subject to, uh, should set corporate strategy subject to control by the shareholders. Okay, my second example is this remarkable case, a decision of the Hague District Court against Royal Dutch Shell, uh, which is under appeal, but I don't think the appeal has been determined. So what the court says in this case is that Shell must reduce its CO2 emissions, including its scope 3 emissions, by 45% as compared with a 2019 baseline, and do it by 2030. Now, this might be an unsurprising ruling of a court if there were a Dutch law or an EU law which said that companies had to do this. But there wasn't. The legal basis of the court's decision was what the courts described in that itself described as an unwritten standard of care deduced from the Dutch Civil Code, which makes it unlawful to act in conflict with what is generally required or accepted according to unwritten law. Now, that is, if I may say so, a most extraordinarily broad and imprecise standard for adjudication by a court. In effect, the court was acting as a legislature uh, And I think that courts in very few countries would have been willing to enter into such a fraught area of public policy on the basis of such an imprecise mandate. We all know about unruly horses and where they may take one. Anyway, the court did. Where did it get the 45% figure from? Well, it looked at the recommendations of various well-respected international climate change bodies, in particular the Intergovernmental Panel on Climate Change. These reports, of course, were not binding on Shell, except through their only recommendations and not addressed to Shell, um, except, of course, as a result of the magic of the Dutch Civil Code, which made them binding. Um, no reason to dispute the science lying behind those reports, but the crucial point is that these reports were talking about the global economy as a whole. These were recommendations that the 45% level should be achieved across the global economy, not necessarily in any particular economy or in any particular company, which might have to do more or less. And so the problem for the court was justifying the read across of the 45% figure from the global economy to Shell. And I think it's in the court's handling of Shell's argument as to why this was too simplistic that one can see the weakness of um, uh, having the court engage in legislation of this type, because the court lacked the data and the an analytical capacity, and also, I think, the political legitimacy to handle Shell's arguments well. So what were Shell's arguments? Well, one argument was um, that um, treating Shell as a standalone obligee to implement this 45% reduction took no account of what other actors in the world might be doing, took no account of the fact that states might be imposing restrictions on the use of oil and gas during this period, that technology might reduce consumers' reliance on these fuels, or that consumers might voluntarily move away to less to greener sources of gas. Now, none of that um, should let Shell necessarily off the hook, but it was a serious argument as to why the read across, the straightforward read across, was not an adequate response to the question of what Shell should do. Shell, all the court could say on this was, well, everybody should do its part, um, which is just inadequate, it seems to me. Because what Shell was asking, or what Shell was saying, was that the court had not accurately identified the part of Shell. Indeed, the notion that everybody should do his part seems to be derived not from this intergovernmental panel, but from a report from a department of a university. Now, I'm sure this was a very distinguished university, maybe even a world-class university. I'm quite happy to accept that because it's actually my own university. But nevertheless, it's very odd that the court should place so much reliance on an academic output for this crucial leg in its argument. Okay, and then Shell's second argument was that, as the court recognized, the main thing that Shell could do under its own control was to cut back on its extraction and exploration activities. And Shell argued that uh, this would just be ineffective because its position would be taken by its competitors. And court partly thought this was an illegitimate argument, though I don't quite see why. If you're, and it partly thought that maybe it wouldn't happen because um, the competitors' products might not be exact substitutes for Shell's products. Um, but this seems to me to misunderstand what Shell would do if it cut back. It wouldn't destroy the assets which it held, it would sell them. And even a cursory examination of the world, I think, would have revealed to the court that there were competitors ready, willing, and able to buy the assets from Shell because they were not subject to the environmental constraints that the court was imposing on Shell. So that's a recent story from the Financial Times about the production ambitions of Saudi Aramco, um, vast oil major standing. Increasing production is its goal, and there are lots of oil companies, mainly state-owned, around the world, which have similar oil production objectives. Okay, so you can see uh, I don't like the Shell decision. um, but and you might think that therefore I'm in favor of the conventional view. Company law does on internal affairs of companies, externalities are dealt by other groups of law. Well, I hope what I've said about Article 15 shows I don't take that view quite, because what I think the second period encourages company law to do is to focus on the interface between corporate law and regulation. We all know that regulation is not self-executing. Um, Regulation relies for its deterrent effect on penalties imposed by the public authorities and or damages actions brought by people who are harmed by the breaches of the regulation. But neither of those things will happen if the breaches are not discovered and action taken. So this is a weakness in regulation. And of course, there are a number of things that regulators can try and do to address this problem. And one is to offer incentives to companies and other organizations whose activities the regulator cannot easily view from the outside, offer them incentives to put in place compliance programs. Incentives in the form of reduced penalties if there is a breach and it's discovered, or perhaps incentives in terms of access to deferred prosecution agreements. Um, so this is interesting from my point of view, because what's happening here is there's an attempt to use the instruments of corporate governance to support regulation. So one's crossing the boundary between external regulation and internal company affairs. And this seems to me to raise the question whether one shouldn't leave this entirely to the regulators, but whether there isn't a role for corporate law uh, to um, um, support regulation, perhaps by giving directors incentives to put in place compliance programs of the type that the regulator is trying to incentivize. And the rule would be, I guess, along the lines of directors would be liable to the company if they fail to put programs in place, and as a result, the company suffered harm, which it might well do if the breaches led to the imposition of a penalty on the company, or if the company took a reputational hit to its share price and because customers were unwilling to deal with it. Uh, Both things you can see in the recent Dieselgate scandal at Volkswagen. Um, so um, where are we? Well, we're in the realm uh, of directors' duties, I think. Uh, if the directors at board level decide the company should break the regulations, then I think there's not much difficulty in finding the directors in breach of their core duty to the company. But of course, typically breaches of the regulation occur lower down in the organization without the board's knowledge of what's going on, or at least without the board's provable knowledge of what was going on. And so really we're in the established area, but underdeveloped area of directors' liability for the discharge of tasks which they've delegated to other people. And most legal systems, certainly the US and the UK, started from the proposition that this delegation was very, liability for this delegation was very undemanding. Basically, and this is the Re City Equitable case from the early 1920s in the UK, if the directors didn't know that the delegatee was unsuitable to discharge the task, or if the if the directors didn't know that the delegatees were actually discharging the task improperly, then there was no liability. And there's a similar outcome in the Alice Chalmers case in Delaware. But recently, there's been movement in this area towards developing some sort of positive duty on the directors to oversee the compliance of the company with the regulation applicable to it, especially where the regulation is central to the company's activities, what the Americans call mission critical regulation. And this has often happened in cases arising out of corporate scandals, such as, for example, the Boeing Max crashes in the US or the collapse of Barings Bank in the UK. Now, these are simply developments. We're beginning to move away from the city equitable approach. Um, this is happening, as is always the case with common law standards, slowly and incrementally, and it's not absolutely clear where we're going to end up, but this just seemed to me an area in which the courts should uh, concentrate on or develop further in the future, because this would be a way of corporate law making external regulation more effective. Or, of course, one could design legislation which imposes an obligation upon companies to put in place compliance plans. So this is actually the main objective of the EU uh, directive, which I was talking about earlier, and this bit too will also apply to companies incorporated outside the EU. And this is a duty in relation to international human rights and environmental standards, a duty upon the directors to supervise the compliance of the company with the standards, but not just the company, to supervise compliance all the way along the supply chain. So the company, subsidiaries, contractors, and subcontractors. Um, and it may even be that the duty will run the other way towards customers down the value chain, though that at the moment is extremely controversial amongst those engaged in negotiating this directive. And then if the company, and so slightly more detail, what the company has to do is to carry out this risk assessment along the supply chain to identify the risks of breaches of the international standards occurring. It then has to take steps to eliminate or to minimize the risks which have been identified in this assessment or which ought to have been identified in the assessment. And if despite these steps, breaches actually occur, then companies will be obliged to take steps to remove or reduce the harm, including the payment of compensation. And if the company fails at any of those stages, it may be liable to penalties imposed by a regulator or to damages actions by those harmed by the breaches of the regulation. As far as the directors of these companies are concerned, the current stance of the directive is that this issue should be decided by the laws of the member states. So it's not clear quite how that will turn out, but certainly in some member states, directors will end up being liable as well if they've negligently failed to see that the obligations of the directive have been appropriately carried out by the company. Now, in principle, I think this is a perfectly legitimate use of the law to encourage corporate law, to encourage compliance with regulation. But there is one particular feature of the EU proposal, which is a little bit troubling, I think. The EU does not think, and I hope it's right, that many breaches of these human rights standards or environmental standards will be found in the EU itself. It expects to find them in undeveloped or underdeveloped third country host states. So this is an example of law being used to redress state action which is broken outside the developed world. Now, I think this is potentially quite troubling on a number of grounds. If the host state is actually signed up to these international conventions and wishes to implement them, but is unable to do so because of lack of institutional capacity, then this sort of use of the foreign company to support the host state seems to me okay. But suppose the host state has rejected the principles underlying the international standards. Suppose, indeed, the host state has never signed the particular convention in question, or suppose, perhaps more likely, the host state has a very different interpretation of what the international standard requires as compared with the EU state where the regulator sits. In that situation, the company finds itself between a rock and a hard place, I think. It will have relatively little leverage against the host state, but it will be uncertain about the extent to which the regulator or the court in its home state will recognize the difficult position in which the company finds itself. And I think it's more likely than not that in many cases, the EU company will simply divest its business from the host state. I put at the bottom of the slide various examples where this has already happened as a result of tort litigation against the top company. And if that happens, then it seems to me there's not necessarily any benefit obtained in terms of compliance with international standards, because the purchaser of the business will undoubtedly be one which is less subject to the pressures to comply. Okay, so that's not quite, thank you. Just one, I mean, let me just now actually conclude and try and give an answer to the question I started out with. So I think I'm trying to make two propositions. One is I'm far from convinced, maybe three propositions. First one is I'm far from convinced uh, that regulation is not the best way of addressing and dealing with the problem of corporate externalities. Second, it seems to me that the benefits of having a corporate law which promotes the internal operating efficiency of companies is extremely valuable now as it was when the ideas were first developed. Third, um, that nevertheless there is significant scope to use corporate law in support of regulation, but not in substitution for it. Does this solve all our problems? Well, obviously it doesn't. There's a whole question of suppose regulation, whilst leaving internal corporate law untouched, nevertheless heavily constrains what companies in practice are allowed to do by way of their business activities. Um, but that, Mr. Chairman, is a subject for another lecture. Thank you.
Well, thank you very much for that most interesting lecture, Professor Davies. We now have our question and answer session, and perhaps I'll kick it off with the first question. Um, a lot of what you've spoken about, Professor Davies, relates to rules and regulations coming out from the European Union. And it's not entirely surprising in a sense because we see this parallel in terms of the regulation of internet companies, for example, right? The EU very much leads in the regulation in this sphere, and many companies around the world have eventually had to adopt these EU standards. But that in part is because technology in this field is quite ubiquitous. You can't stop someone from accessing a site from somewhere in Europe, for example, and therefore, in that sense, there is the presence of the company within Europe itself and therefore subject to European legislation. Um, in this space, do you see a parallel? Because it doesn't seem to me that there are too many other countries going to the same extent as the EU. And therefore, I'm sort of curious whether this will kind of lead to a truncated world or ultimately ineffectual regulation, given that, EU in terms of pure economic power is probably not the powerhouse that it used to be.
So that's an extremely interesting question. And you can see that the EU itself was worried about this through its decision to um, uh, apply the rules to companies incorporated outside the EU, which meet a certain turnover threshold. That really puts companies outside the EU, which don't like these sorts of rules, into a difficult position. They either give up the European market uh, or they comply with these rules. Now, I can't tell you which way it's going to go. Um, uh, I guess the compliance obligation applies only to the supply chain of the products or services which are delivered within the EU. So if the company is sort of got a divided setup in which it sells some products in the EU and some products, but not elsewhere, and some products elsewhere, but not in the EU, it would only be subject to this obligation partially. But I agree. Uh, what you could have is an example of the law being used to go against globalization and to produce a sort of a division of the world into competing trading blocks. Um, but as to which we'll get, I can't tell you.
I can, for example, see that a company that's incorporated in the United States, for example, might have a subsidiary in EU. And I can see that the EU core obligation seems to make it make the American parent perhaps responsible for what its subsidiary does within Europe itself. But assuming all that to be the case, to what extent can enforcement really take place against the American parent unless America itself recognizes the effectiveness of these laws? Because otherwise there will be extraterritorial assertion, for instance. And I just wonder to what extent that's a problem even under EU law.
Right. So that I think they have taken care of. So in your example, where the US parent operates through the EU, in the EU through a EU subsidiary, then the company that's subject to the obligation and would therefore be subject to the sanctions is the EU subsidiary. So there's no extraterritorial application of the law. There may be a practical extraterritorial impact, but not a legal one. There's no sanction against the parent company in the US. It's against the subsidiary uh, of the parent in the EU, in whatever state of the EU the subsidiary is incorporated. Now, of course, one way the American parent might try and get around this is by dissolving its subsidiary and trading in the EU via a branch. Um, uh, but in that case, there's a system for registering the branch in the EU, and the sanctions are applied to the branch and its assets in the EU.
Thanks very much for this. Perhaps now I can turn over, yes, to the floor. Umakan?
Thank you, Professor Davis, for your stimulating lecture. I just had one broad question that cuts across your main theme, but I'll break it down into three parts. The first part is I was wondering whether this understanding of the first period and second period, is it really that binary? Because we see a lot of overlaps. For instance, the concept of enlightened shareholder value was developed in the first period, even before this whole corporate purpose debate became so pronounced. So is that really like a marked shift that we see, or is it like a brief change? So that's kind of the first point. The second point I had was relating to your internal corporate law regulation and external regulation like environmental law. Yeah, even there, wouldn't you say that there is a role for both? And corporate law can play a role more than just nudging, because it's all about internal decision making regarding how a company should deal with environmental risks or climate change risks. So there's something in between. So it's not again external versus internal, and internal regulation is not just about nudging. There's a lot more complex decision making regarding the board. For example, directors' duties, the KMARC duty that you mentioned, that will also be important. And the third part is I was wondering whether the agency problems paradigm, which is evident from the first period, would it also not apply in the second period? Because even shareholders are concerned about questions like climate change. So even if, for example, Shell, or if I'm a shareholder of Shell or Saudi Aramco, I may not just want the company to engage in more fossil fuel oriented approach, because that may in the long run be detrimental to the shareholders. They may have to start thinking about changes, whether due to regulation, due to market, or otherwise. So the agency problem applies, but maybe the nature of the agency problem changes over a period of time. So the directors may be concerned with different sorts of agency problems today than they were during the first period.
Right. Thanks so much for those. So you're quite right about overlap. I mean, in some ways, taking the two periods was a sort of rhetorical device. Um, Indeed, my whole one of the points I was trying to make, one of the arguments I was trying to make, was that the lessons learned in the first period continue to be important in the second period. So it isn't as if the world changed in 2008 so that one set of values was out of the window and a new set of values came in. I tried to frame the problem in terms of a set of supplementary or additional concerns coming in the second period. And indeed, one of my main points is that the first period concerns continue to be important, that they are valuable for the proper construction of corporate law on a continuing basis. So, yeah, if I was I seem to be giving a different impression, then I didn't want to. Um, 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 the second point was about, oh yes, the second point I agree with. Uh, uh, I don't know whether you're trying to suggest that corporate law should do something beyond the supportive role that I identified, but I was trying to focus on the decision making of the board in relation to regulation and seeking to suggest ways in which corporate law liability rules could, in fact, strengthen the position of regulation by bringing it into the company, which I think is really important in large organizations where the regulator really never discovers in time or what's going on until there's a complete bust up. And therefore, anything that corporate law can do to ensure that regulation is adhered to within large organizations, or that problems are discovered and fixed before there's a bust up, is very valuable. Um, on your third point, um, well, uh, it's conventional for speakers to say, "I'm glad you asked that question," when really what they mean through gritted teeth is, "I wish you hadn't asked it at all." Um, but in this case, I am glad because what you were hinting at um, is that shareholders might have views on things like climate change. So we all know about ESG investing, investors who invest to achieve environmental and social goals as well as financial goals. And I didn't talk about that, partly because I didn't have time, um, partly because it's difficult to know quite what to say. But in terms of my analysis, a set of investors who want to achieve social or environmental goals as well as financial ones are engaged in positive externalities. In other words, they're conferring benefits on society, which they're not being remunerated for. And the question is, why should they want to do that? Uh, and it depends, I guess, on what their goals of investors are. And traditionally, we thought of investors as having purely financial goals. So the focus was basically on the share price. Um, Suppose shareholders change their views and want to, as Hart and Zingales have recently suggested, and want to achieve a wider range of objectives. Well, um, in a way, I think I was right not to touch on this because actually it doesn't present much of a challenge to the corporate law that was developed in the first period. Because if it's the case that uh, boards are supposed to be sensitive to the requirements of shareholders, then as shareholders' goals change, so should the way that the directors manage the company and the directions they take the company in. So curiously, ESG investing, I think, has presents less of a challenge to the first period nostrums than do negative externalities. I mean, whether there's anything in ESG investing, well, your guess is as good as mine.
Can I
Uh,
just, yes, Hans, please go
yeah,
ahead.
sorry. It's just to follow up on Professor Umar Khan's question. Thanks for an incredible lecture again. So I was talking to this fairly large investor and trying to convince him to sell his ExxonMobil shares, and he said, "But Warren Buffett is buying Occidental, right?" So it's very hard, I think, to get shareholders to actually change. I mean, we may have a vision of what we want a shareholder to be, but I think that we can keep it at that level, and to expect them to actually change may be more difficult. But it comes back to what I really liked when you concluded and said that maybe company law should be about the internal side of things. But I just wonder whether your story is a story of overshooting as well, that we became so internal in the first stage. And it's understandable because in the 70s, the unions are very strong, the shareholders weren't making any money, that we started protecting shareholders more and more. The agency cost story came about, and that sort of overtook any other story there was. The minority shareholder story also came about in small companies and even in large companies, that we somehow then overshot and we actually protected shareholders too much. And I wonder whether it's because we actually made the internal so narrow that we left out creditors, especially the non-adjusting creditors. I think on your story, creditors can bargain and therefore they are internal. But the non-adjusting creditors, and that, of course, that's a very wide group. If we took them into account earlier on, we may not have gotten to the stage now where we may be overshooting in the other direction with all these purposes out of Holland and so on. And I like what you're saying, which is why not we stick with what we have, look at directors' duties, and try and find a way of incorporating all these external things, as opposed to trying to ask shareholders to be good and directors to be good as well.
Yeah, well, I agree. There may have been overshooting. I don't think that's inherent in agency theory because, as I say, it's a way of framing the problem. It doesn't tell you in precise terms what the solution should be. That is to say, it certainly suggests that boards should be accountable to shareholders, but it doesn't tell you how strong or immediate or rigorous that accountability should be. And in fact, jurisdictions around the world vary, don't they? I mean, America used to be, though I think no longer is, or Delaware used to be, is no longer is, um, a board-centric system where the levers available to the shareholders to get rid of directors they didn't like were limited as compared with the UK, where it's extremely easy. Yet they're both countries in which agency theory was applied. So there's clearly a range of choices within agency theory. And I think there is a lot to the view that we overshot, at least in the UK, and that it's sometimes in the best interest of the shareholders that they can't remove the directors immediately, but must sit and wait and see whether the projects which the directors have invested in actually work out.
Thank you very much. Can I just ask if any other member of the audience has a question?
Okay, my name is Wee Liang, and my question is the divide between internal, outside, and inside is, as you said, a framing question, right? In order to get the outcomes you want, you have to have mechanisms within. So that's the issue that your discussion does not address, because by saying clearly what's outside should be not imposed upon the directors, uh, doesn't quite communicate the reality. The reality is, if we follow the analogy that the brain of the company is the board, then who else would you have who's supposed to be allied with the shareholders by virtue of being elected by shareholders to be aligned with their interests? Okay, that's just the question I want to ask you is, how do you define the line between outside and inside? And the second question I have is, you hinted that in your mind there's something that law should do and there's something regulation should do. So, but what, for clarity's purposes, could you define what regulation you think of versus what the law should be? Because in my mind, it could be that the law simply says the board follows regulations and assume that those who draft regulations are more conversant with what local conditions are, or something like that.
Okay. So the distinction between internal and external is essentially whether you've got a contractual relationship with the company. If you've got a contractual relationship, you're internal. If you don't, you're external. And now I wasn't trying to draw a contrast between regulation and law. I was trying to draw a contrast between two different bodies of law, namely corporate law on the one hand, and regulation, which maybe I should have made clearer, are used to refer to any body of law which isn't corporate law. uh, uh, and um, so I think there's value in preserving the contribution that company law makes to the efficient running of companies by keeping those two sets of rules separate, except that I do very much accept the notion that corporate law has a role to play in making regulation more effective. But of course, um, um, this is a step which is a second order question. The regulation has to be adopted, first of all, outside corporate law, and then corporate law is used to make the regulation, whatever it is, more efficient by dealing with the regulator's problems that it can't work out what's going on inside complex organization. And as I said right at the end, I haven't talked at all about what the appropriate scope of regulation should be. And indeed, I think this is an impossibly difficult question. Um, uh, I mean, it's always been the case that companies have to operate within rules set by the state. Uh, and that's just so, um, uh, and the companies just have to take that on the chin. I mean, or they have to adjust their operations accordingly. They just have to accept that the regulation is there. Adjustment may, of course, involve leaving the jurisdiction if you don't like its regulations. Um, and there's a recent article by Ron Gilson and Curtis Milhouse, which suggests uh, countries go through cycles. Sometimes they focus on maximizing the freedom of companies to carry on their business activities. Other times they want to constrain those activities um, uh, in pursuit of other social goals. These things come and go, that different companies, different countries, maybe at different points in the cycle at the same time. So Japan may be at one point in the cycle when the US is at a different point in the cycle. Um, um, so, so, but all that I was leaving to one side.
Thank you. Yes.
Professor Davies, thank you for your lecture. My name's Ben, and I wanted to ask about whether you think, just building on what you said about countries going through cycles, whether it might be possible that in the EU case, because of the Charter of Fundamental Rights and how directives and regulations have increasingly to be interpreted in light of the Charter of Fundamental Rights, whether the tendency for the EU to sort of move away from the current sort of pro-rights, pro-environment tendencies would be less than it would be the case for, say, Anglo-American jurisdictions or Asian jurisdictions, for example.
Yeah, that's an extremely interesting question, and it's the subject of intense debate within the EU. So there's not a single view amongst EU member states. This particular directive I was talking about is clearly the result of agitation which began with civil rights groups at the UN level. So the UN Committee on Human Rights was the first group to propose the notion of uh, co-opting companies to enhance states' adherence to human rights treaties. Um, and that has been taken up by at least by groups within the European Commission uh, who are very much in favor of this sort of approach. Um, and business, I think, didn't see this coming and has been trying to play catch up ever since the Commission made its first proposal and has been trying to chip away at the proposal with limited success. But if you look at the debates within the Commission, within the Council, within the European Parliament, there's clearly a range of views. And my guess is that you're right that um, those who propose a rights approach um, are in the ascendancy at the moment. Um, for how long, who knows?
We're drawing close to 6:30, so I'll give the final question to Ming Sing.
May I be allowed to retrace a little bit what Hans asked just now, right? Because he raised a question about companies being allowed to run more and more for the benefit of shareholders to the detriment. I mean, he mentioned creditors. So I think this may have something to do with actually with regards to the first example that you gave, Prof. Davies, because you talk about maintenance of capital, right? Because we have progressively whittled down this doctrine, which many of us do not like, but maybe it is there ultimately for a good reason, right? Because the move to solvency test has not been accompanied by strong safeguards, and we see that in the recent case of Sequana, right? So I would think that when you mention about functions of company law, it's not, I suppose you will not think that is not restricted to just duties on directors, but there's also big scope for mandatory rules, things like maintenance of capital, right, to protect creditors' interests. I mean, although this is, I agree with you on your how you frame the question, this will be internal. Then the second thing is, I just want to, it's just something that come to my mind, because this thing about ESG, I share the skepticism. Okay, actually, not so much from Hans, but from maybe you mentioned something along those lines that why would shareholders, why would they, in a way, be bothered by these larger considerations? Because many of them, they may have certain missions to achieve as well. Like for example, pension funds and all that, they have to meet certain targets, right? In fact, many pension funds are already underfunded. So I cannot see how they would not want to invest in companies that deliver good returns to them, right? Because they need to meet their recurrent immediate needs, right? So if that's the case, why is it that all this talk about ESG, how did this thing arise? Because I agree with you, because I've always thought that regulation is important, but this putting this ESG up, right, and kind of ignoring regulation, has that something to do with with the political discourse, right? Because of this rise in conservatism, at least in some parts of the world, right? So we want small government, right? If you want small government, that must mean that you do away with regulation, less regulation. So now you push the debate to ESG, which I think is going nowhere, because I think it's very hard, right, to expect shareholders to be altruistic. But putting aside the uh, I mean what I said earlier, right? So I just think that this whole thing about ESG, um, there may be something darker to it. Sorry, I mean, I'm not into conspiracy theories, but I just wonder, how this thing can come about in such a drastic way, where it has never been shown clearly, how 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 to walk down this path, right? In order to cause companies to act in the way on their own volition with minimal outside regulation. Right? I mean, I really can't see that. Thank you.
Yeah, well, I mean, I share your skepticism about ESG, or at least I don't think we know enough about where it's coming from. Um, I mean, there are very cynical explanations you can give. Namely, it's good for um, our fund managers to have ESG funds because an ESG fund requires some element of selection of companies to invest in, and therefore the fund managers can charge higher fees than they can in a purely passive fund. So they're quite keen on ESG funds. But that will all end in tears unless there is a, a real substantive movement on the part of at least some investors to want to trade off financial goals for some level of other objectives. And I don't know, I don't think we can even measure that at the moment. And this, of course, would create a big problem for companies because uh, under the old Friedmanite view, which is that the purpose of the company is to make profits and nothing else, then all the investors focused on and all the board had to focus on was the share price. But if you're talking about ESG investors, there's likely to be a heterogeneous range of goals. Some investors will prefer social objectives. Others will prefer environmental objectives. Within those groups, people have different views about which objective should be prioritized. So that's going to make life very difficult for boards to know what metric they should be focusing on. So one thing that I don't know whether it's corporate law or fund management law would have to do would be identify some way of converting these heterogeneous preferences into a single metric which the board could pursue. But it's not obvious to me how you do that. Hart and Zingales have suggested you have referenda of the shareholders from time to time, but coming from the jurisdiction I come from, I'm not much in favor of referenda.
Thank you very much, Professor Davies. We've come really to the end of our question and answer session. And as the moderator, I will just conclude with one observation, which I promise you I will make very succinctly. And it is that, I think the reality of it is that company law can certainly nudge corporate citizens towards better behavior, right? Professor Davies has spoken about directors' duties, but another example really relates to the rules of attribution, right? Because you certainly don't want directors to hide their heads in the sand and say, look, we didn't know about this and we didn't know about that, and therefore we're not responsible, right? So rules of attribution are another way in which company law can nudge senior management towards behaving in a better way. But I think the fundamental problem still is, what are you nudging them towards? Because you still need to have, first of all, the policy clarity of what is right and what is wrong, right? What companies ought to be doing, or what companies, or in fact, citizens in general ought to be doing or not to be doing. And unless we have that clarity, company law alone is not going to cut it, right? In the EU, I can see there's a lot of political will, because I think the government and the citizens all generally appreciate that climate change is a problem and something needs to be done. But there are also other big economic players where the level of political discourse is so divided and there's so much skepticism that government itself is divided and they can't make those policy choices. And in those countries, I can see how interest groups are trying to nudge companies by virtue of the so-called process of putting pressure on companies, rather than it being clearly done through the legislative or regulatory scheme, right? And I think that's part of the problem that we're facing today, right? But on this note, as I said, I'll keep my remarks, my observations succinct. Can we all please come together once again to thank Professor Davies for most fascinating lecture. Thank you.